its children, file number 22217.
Okay, we are in the file this afternoon for purposes of review. And let me see if it's set for PPH as well. Yes, review and permanency planning hearing. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Stephanie Hamlin, Department of Health and Human Services, foster care.
Nastasia Thomas, counsel for the department.
Michael Brooks, I represent the mother, Samantha Mikulik.
Name for the record, please.
Samantha Michael.
Ms. Berger,
Good afternoon, Ariel Berger here on behalf of Father Robert Paul.
your name, please.
My name's Robert Paul.
Thank you. All right, Ms. Heiss.
Thank you, Your Honor. I had a visit scheduled in person on July 6th during a parent visit, but the visit was canceled. The parents did not confirm in time, so that the visit was canceled. So then I went to visit them again, and they're broken out with hoof, foot, and mouth disease, so I Zoom visited with them. I've never seen a case of hoof, foot, and mouth disease like this, however you say it, hand, foot, and mouth disease with a breakout like Jameson has. But the children remain in foster care with folks who are providing for their needs. The court report indicates that we haven't had the progress in parenting skills that we need to see, lots of missed visits, lots of not prioritizing the children's needs. Especially remarkable is that these children can't hear very well, and the father also has had some hearing struggles in the past, yet we're not seeing these parenting skills where the parents, are letting the kids know what they need. The kids aren't coming to the parents right away. They're going to the toys first. The parents still aren't coming along with the feeding of the baby, and without the supervision, I don't know. I think it's too much of a risk to go to unsupervised even at this late date in the case. So I do join the agency in recommending the goal change to adoption. These children need permanency, they need finality, they need all these medical and educational appointments. They have bonded with these caregivers, and their needs are being met in the current placement. Thank you.
Thank you, Your Honor. Ms. Hamlin, can you please be sworn in?
Ms. Hamlin, come on up to our witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Good afternoon, Ms. Hamlin. For today's hearing, you have prepared a court report including the court report. I'm sorry, my page just jumped. Trying to see how many attachments you have. Just make sure we all have them. Looks like there are 19 attachments and about 91 pages, inclusive of your court report. Are there any updates or modifications that you need to make to your court report or those attachments?
Ms. Mikulik did gain employment since I submitted the report. I believe the restaurant is Sauce. Did I say that right?
I might need you to speak up a little louder.
Okay, I'm sorry. Ms. Mikulik did gain employment since I submitted the court report. She started at Sauce this week. I cannot recall the position she's in at the moment. That's the only update.
And at this time, the children remain in a licensed foster care home, correct?
Yes.
And do you believe that they are, the foster parents are exercising the reasonably prudent parent complying with the reasonably prudent standard?
Yes.
They're developmental materials for the children, developmentally appropriate materials for the children, and activities for them to engage in?
Yes.
And there is an older child Jade in this case. Are there any sibling visits that are occurring?
There are not. Mr. Richards, Jade's non-respondent parent with whom she resides and who now has legal custody of her, has stated he does not want her participating in visits. He's concerned that she's going to get her hopes up that the boys will be going home to their mom and she'll be able to see them regularly again. And he does not want her to get her hopes up and then be disappointed.
If he were to have a change of heart in that regard, would the foster parent support that relationship?
I believe so, yes. It's not something we've talked about extensively as the goal has been reunification. But they were willing to participate in video and in-person visits if needed.
And at this time, the current permanency goal is reunification, correct?
Yes,
And are you asking for a goal change today?
yes,
And what is your request for the goal change?
to be changed to adoption.
And you elaborate as to what the substantial risk of harm would be to the children as relates to the reunification.
There would be a significant risk of harm for medical neglect, physical neglect, risk of homelessness, likely academic and or developmental neglect in regards to all of the early on services for the boys. I have significant concerns regarding the parents' ability to meet the children's special needs.
And that sort of leads me to the question of the parents' level of compliance with and benefit from their case service plan. As relates to the children's safety and the parents' case service plan, how would you describe the parents' compliance and benefit from the services that they have either been offered or have engaged in?
I would say there's been partial compliance, but I'm not observing any demonstrated benefit. Ms. McLeod does attend therapy with Barb Brick through CPIF. However, there has not been an observable improvement in her daily living or her parent-child visits. We did recently transition the visits from Ms. Edwards to more counseling services as they are able to offer a hands-on education program, which both parents have stated that that is more beneficial to them. However, there is still a significant number of missed visits. Despite registering with MRS, Ms. Mikulak hasn't done a whole lot through that agency. She's done a lot of applying for jobs through Indeed. This will be the third job she's had since the kids are in care, with significant periods of unemployment in between. Her finances, she hasn't provided a budget. There's a lot of question as to where or how they are able to procure enough money for rent and other necessities. Mr. Paul has missed 3 or 4 intakes now for his anger management. He is still on the wait list at ACPC, I think it's called, for individual counseling. They did indicate that there was about 2 more weeks before they should have an available therapist, and that was about a week ago. We are in the process of referring Mr. Paul for a cognitive evaluation based on the recommendation of more counseling services in regards to the ability to learn and maintain appropriate parenting skills.
As it relates to the anger management component for Mr. Paul, in Ms. Edwards' notes, there seemed to have been a lot of effort put forth to scheduling that. Can you elaborate, I guess, or clarify how he's missed so many, but it seems that he's also put a lot of effort into trying to schedule that?
So prior to the parenting visits being through more counseling services, we had referred Mr. Paul to Brene Moore for anger management. Ms. Edwards made numerous efforts with Mr. Paul to contact Ms. Moore and to get things scheduled and started. Once the parenting visits were there, the Ms. Janice Van Brunt, I'm sorry, I cannot think of her position offhand, was able to work with Mr. Paul and is able to provide him with anger management. They've scheduled, I want to say 3 or 4 attempts just within the past month that have been missed.
I just want to bring to your attention, and I believe that this is just an oversight perhaps on your part, on page 56 and with mark 56 and 57 of your report is the Counseling Services Assessment Treatment Plan report from CPIF regarding a different family with the initials of DH.
That is definitely an oversight.
Okay.
I apologize for that.
Would you like the court to strike that from your report?
Yes, please.
Your Honor, I would ask the court and counsel to strike or delete, omit pages marked 56 and 57 from the court report, as it is relating to a parent that is not part of this case.
No objection.
I have no objection.
No objection.
Thank you. 56 and 57 have been eliminated.
Thank you, Your Honor. And as it relates to these parents, you, in your court report, there's a mention of some traffic stops or instances with Miss Michelin. And at this point, are you aware of, do either parents have licenses?
Not that I'm aware of. I believe hers is suspended and don't believe Mr. Paul ever had one.
And do you know if either or both of them have outstanding fines to pay regarding that?
I believe she does based off the most recent traffic stop.
And your report indicates that there were several medical appointments for these children, correct?
Yes.
Have the parents been able to demonstrate an ability to get themselves to and from important appointments?
No.
And if the children were in their care, do you believe that they have a plan or an ability to get the children to their medical appointments?
No.
And as you made a comment about concern about the parents' ability to manage their funds correctly, and in your court report, you highlight a couple of different instances as to why or how that's a concern. Can you please elaborate why that poses a risk to the children if they were to be returned?
I believe there would be significant risk of the children's physical needs not being met. The respondent parents have not always been able to provide formula or baby food during visits as required. Sometimes what they've brought has not been usable as it's been expired, or they don't come prepared with the right size diapers. I don't believe they're accurately managing the funds that they have in a way that would support the financial aspect of raising children.
Your report indicates things like getting nails done using DoorDash versus, but also using like a community resource for food. Have the parents demonstrated an ability to put their desires to the side in order to provide for their own basic needs?
No.
Are there any other referrals or services that these parents can be offered to assist them in the barriers that exist to reunification?
I do know Ms. Janice Van Brunt is able to provide like an adult life skills type program that can be tailored to a specific client's needs. We can look at something along those lines. I believe with that, she prefers that the clients also receive a cognitive evaluation so that she's able to tailor the services to fit that client's style of learning. I don't believe either client would qualify for CMH or their independent living skills program.
At this time, what is the current parenting time schedule?
It was reduced during this reporting period. So in the beginning of the reporting period, it was 3 visits per week. I want to say around May 26th-ish is when it was reduced to 1 per week. That was also right around when we had submitted the referral for the hands-on education component with more counseling services. So we were initially offering that hands-on coaching, and then 1 visit still with Ms. Edwards, who has been the primary visitation specialist throughout the case. However, Ms. Van Brunt's recommendations were that they needed a minimum of 2 sessions per week to make any headway on parenting skills. So they are currently doing 2 coaching sessions per week, or they're scheduled to do 2 per week.
The report indicates that there have been 12 plus visits that have been missed. Have the parents indicated what barriers exist to attending those visits or to medical appointments?
They've indicated that transportation is a barrier. We've discussed it during some of their parent aid sessions. When myself and Ms. Edwards have done home visits, we brainstormed and came up with a way that the department could assist in having their car repaired. At first, it was not a muffler issue because Ms. McLeod did get that fixed, but it was some other sort of like tire issue with safety that the department was willing to pay half the funds towards having repaired. However, right around then, there was something thrown at the windshield by a neighbor. So then the windshield was completely smashed. And then shortly after that was Ms. McLeod's traffic stop where she was then arrested and lodged and the vehicle was impounded. Ms. McLeod reports that she has since sold the vehicle. So at this time, their transportation is rides from friends, their bikes, walking, or they've just requested bus tokens. So those will be provided today.
And as is parenting time, all of parenting time is occurring within a reasonable distance for a bike or walking to be appropriate.
Yes, it's 2.3 miles from their home to more counseling services.
Okay. Do the children have any unmet needs at this time?
They're both on a waiting list with University of Michigan, Mac Children's Hospital Pediatric Genetics. Jameson has been on the waiting list. Avery was just recently added to it when his auditory brainstem response test showed that he had the same exact type of hearing loss as Jameson. With it being permanent for both boys and of the same type and severity, early on has requested that both boys have genetic testing completed. There is also some concern based off facial features that was noted by early on, as well as more counseling services, that there could be some type of syndrome that's undiagnosed. Early on is quite concerned, as it's unknown at this point if Jameson's severe developmental delays are attributed because he went an entire year without having his hearing rechecked prior to coming into care, or if it can be attributed to an unknown genetic condition.
And the agency has the ability to consent for any form of treatment.
Mr. Paul and Ms. Mikulak have been compliant with consenting for treatment. Sometimes myself or Ms. Edwards has had to facilitate that, but so far they've been able to consent to everything.
And as relates to Jade, the home visits that you conducted with Macomb County or in Macomb County, have those all been appropriate?
Yes, I've been to the home myself once, and the other home visits and face-to-face contacts were made by Macomb County DHS with no concerns noted.
And thank you for including the consent order for custody. Let's see. And it refers back to our case regarding parenting time. What is the current parenting time for Jade?
It's quite liberal. At this, since I came on the case, Ms. Mikulak and Mr. Richards have kind of set it up themselves of how it's always been. I believe in the beginning of when I was on the case, Ms. Mikulak was seeing Jade just about every weekend with Mr. Richards or one of Mr. Richards' relatives supervising. However, that has dwindled as there's been the transportation barriers, poor weather conditions. So they're averaging about once a month.
And are there any, Jade is 7 years old, correct?
Yes.
And is she capable of speaking?
Yes.
Does she have any developmental delays?
Not that I've been made aware of.
If she were in an unsafe environment or situation, would she be able to articulate that?
Yes.
Do you believe that the custody order and the parents, Mr. Richards and Ms. Mikulak's, their communication and their ability to set up those visits is sufficient to safeguard the child at this time?
Yes.
And you are asking that she be released from this case?
Yes.
And is there anything that else that you'd like to highlight from your report or the attachments for the court today?
No, thank you.
Thank you. Your Honor, I have no further questions for this witness and move to admit the court report with its attachments, with the exception of those pages that have been taken out at this time. Thank you.
I have no objection.
No
None.
objection.
Thank you. They're received. Questions, Ms. Berger?
Not at this time. Thank you.
Mr. Brooks?
How old are these kids?
Jameson is 2 next month, and Avery will be 1. August 1st and August 22nd, I believe.
They're early toddlers.
Yes.
Now, I noticed that the case file number on this starts in 22 September, I believe, almost October of 22.
Yes,
And we are now nearing the end of July 23. Don't you think it's a little early to be recommending a change in goal?
the department's policy is to have permanency achieved at the 1 year mark and not just changing the goal at that point. So at this point, I believe changing the goal is appropriate as neither parent has demonstrated compliance or any benefit or even significant participation in the case service plan or parenting time.
I was looking at Mrs. Danot's progress, and there were quite a few satisfactory or partially satisfactory grades, if you will call them, in this report. Is that right?
Yes,
Compliance, non-compliance, partial compliance. With
yes,
the right term on it. You don't think all those partial compliance evaluations have earned her more time to get it together?
I think it would be appropriate to change the goal now with an actual trial set approximately 90 days out. If at that time she has demonstrated significant improvement, the department would consider withdrawing the termination petition. But I do still recommend that the children's goal be changed today.
Thank you, ma'am. That's all.
Mr. Paul's psychological evaluation resulted in some recommendations, and you're familiar with those?
Yes,
So if reunification were to be ordered, the expert has given us a list of things. I wonder, has Mr. Paul even begun or accomplished a clear understanding of what abuse and neglect is?
it's being attempted in the parent education. However, both parents have been very hesitant about completing the homework assignments assigned by Ms. Van Brunt. Attending all of the sessions as they are generally held prior to parent visits. And Mr. Paul did have a delay in registering for the wait list with ACPC for an individual therapist also.
Thank you, nothing further.
Sure. Any redirect?
No, Your Honor.
Okay, any recross, Ms. Berger, Mr. Brooks?
Did you check to see whether or not this couple is literate? Can they read?
They both reported at the beginning of the case that they were literate. I have not asked them that question directly.
Thank you.
So I'm looking at the custody order. It does look like he's been directed to attach the affidavit of parentage, amend his complaint for it to proceed. Also that the parenting time would be as mutually agreed. Does that cause you any concern about the permanency for Jake?
I do think Mr. Richards is capable of protecting Jade. I don't believe he was as knowledgeable about her living conditions and circumstances as he would wish. He has expressed significant remorse over not stepping in prior. And he does now have a copy of the AOP as we provided the original for that in the birth certificate.
Okay. Any follow-up?
Just briefly, Mr. Richards supervises all contact between Mrs. McElec and the child Jade, correct?
Mr. Richards or one of his relatives. Yes.
Thank you, nothing further.
Ms. Berger, did you have any questions?
I have none, Your Honor. Thank you.
Thank you for your testimony. You may return to your seat. Any other witnesses?
No, Your Honor.
Ms. Berger?
Mr. Paul, would you like to testify today?
Could you speak up? I'm not sure she heard you.
No, I'm okay.
He says no.
If you have questions after the hearing, call me, okay?
Okay.
Okay, thank you. I have no witnesses.
Mr.
so-
Thank you.
Ma'am, do you want to testify? She's shaking her head no, Your Honor.
Ms. Heiss, anyone you'd like us to hear from?
No witnesses today, thank you.
Right, comments then, Ms. Thomas?
Thank you, Your Honor. The department is asking for the goal change today to be to adoption. As Mr. Brooks pointed out, it is not quite a year into this case, but the children are very young. They do have some significant health and developmental needs that need to be addressed by caregivers who are capable of understanding that and putting those children's needs first. And their needs are being met in their current placement. And so we ask that the permanency goal for those children be changed to adoption. And as it relates to Jade, she has been with a non-respondent parent who has officially secured a custody order. And as Ms. Hemlin testified, the parents have been exercising this sort of parenting schedule for quite some time now. And the child is older, who does not have the same sort of concerns that the younger two children have. So we believe that that is sufficient to safeguard her and provide her with some permanency. We would ask that the case service plan perhaps also be modified, or somehow this court recognizes that, or assist the department ordering the parents participate in a cognitive evaluation or assessment to determine a baseline as to what further needs they may have, whether it's life skills or something more tangible, because all of our efforts do not seem to resonate, whether that's the hands-on parenting approach, significant efforts by Ms. Edwards. The reports that we're seeing are still indicating lack of benefit. And we understand that there are some barriers such as transportation, but some of that is also a direct result of the mismanagement of funds that are available to this family. So for those reasons, we ask court to find that there's still a substantial risk of harm to returning the children today, and change the permanency goal to adoption and set this for another 90-day review. Thank you.
So you'd like me to add to the order that they submit for that developmental testing? Is that what you're thinking?
If that, because it's not part of the case service plan, and so if the most efficient way is for them to participate in that cognitive evaluation, I'm not sure the correct name of that testing, but it's essentially to give us it's psychological. Sorry, Your Honor, but something to understand the cognitive abilities and functioning of both parents. Yes.
I just wanted to clarify what you were asking. Thank you. Okay, any comments, Ms. Berger?
Thank you, Judge. At this time, we would just ask for more time to work the current case plan services. It is a bit early, and based on the court report, there does seem to be quite a few compliant or partial compliant categories listed there. So at this time, we are just asking for more time before that goal officially changed. Thank you.
Mr. Brooks?
I'm bothered by the comment from the caseworker that my client and her significant other do not appear to have done the homework that they had been provided, which is why I asked the question about whether she knew they were literate or not. And I would ask the court to instruct her, she being a caseworker, or her agency to make a determination whether or not these folks can read. I know it's a personal thing, I know it's embarrassing, but I think it's necessary. If they can't read, they can't learn.
Ms. Heiss.
Thank you, Your Honor. There is an IQ test in the psychological evaluation for Mr. Paul, and it does represent some weaknesses in abstract reasoning and verbal information. However, to be at this point in life without supports in place would indicate that they're not prepared to handle these children. The hearing loss that these boys have endured, then the parents didn't go to that one appointment that you would think they'd want to be at, the one where the hearing aids are put in and they hear, didn't go. I did visit, just for the record, with Jade by Zoom. She's located in Macomb County. I did visit with her too, and that father is very astute. He has got the custody order that we asked him, that was requested of him, and that he seems capable of protecting that child. Visits happen at times when he or someone in his family can supervise that child. So back to Mr. Paul just a minute. He has, in his psychological evaluation, elevated scores on important scales, including low frustration tolerance, tendencies towards impulsivity, less life satisfaction, poor ego development, an individual with a significant amount of distress and unhappiness. He has vulnerabilities to being overreactive. He is suggested to be a person with rigid and unrealistic expectations in terms of the behavior of a child. These are despite the possible intellectual challenges that they have, and I would ask you to consider these children having been medically neglected and in fact injured, need these parents to have been able to respond to the interventions that have been put in place for them, and they are not responding to those. The little one has been in care most of his life. He's bonded. The older child, the new testing that's coming through on him and his new ability to hear changes things for him. He is now allowing the caregivers to touch him more and cuddle more and that kind of thing. The children are ready for permanence, and I do agree with the goal change to adoption. Thank you.
Well, the court finds all interested parties were given notice for purposes of today's review hearing. I do find efforts towards the goal and reunification are being made. That was based on the court's review of the exhibits, as well as listening to the testimony of our caseworker today. I also find Ms. Heiss in satisfaction of her obligations as guardian ad litem. As I look at permanency, Ms. Hamlin makes a really good point that we would like to see permanency for children achieved within a year, especially children at such a young age need to be in an environment, especially children with such significant special needs as these children have, need to be in an environment where they can concentrate on reaching their developmental milestones and having support systems in place so that they can have access to the service providers that they need to in order to make that progress. We have here a set of parents that do have some limitations. Those have been somewhat documented already, as Ms. Heiss articulated, and I would agree that I think there is a combination of natural limitations and also some apathy, if you will, towards those limitations and how significantly those limitations have been for their children in this case. And we saw that in the initial filing, and we continue to see that with the children who will be in services on a very long road to overcome many of the challenges that they were both born with and had no attention to during the period of time that they were in the primary care of their parents. There are also significant concerns being expressed by our visitation coaches and supervisors for Mr. Paul's visits, including poor knowledge of age-appropriate expectations and safety, poor knowledge regarding children's special needs, inability to read or understand nonverbal cues from his children, poor knowledge of how to engage with the children, providing and failing to provide for their needs. Many of the same limitations apply to Ms. Michaelak, as well as for her, there's continues to be some disturbing behavior and aggression, although it doesn't seem to be as prominent or dominant as it was last time. So I'm glad to see that. Perhaps most concerning as it relates to their loss of transportation is the fact that that along with some of the other demonstration of limited commitment to making it to parenting time has resulted in both of these parents missing significant amount of parenting time visits. Mother is reported to have attended 20 out of 32 visits, father only 18 out of 32 visits. As noted by Ms. Heiss, missing significant medical appointments for their children, all of which are very significant. The oldest child has had, as a result of the early on evaluation, limitations in pretty much every single area, and is functioning at 7 to 8.5 months in many areas when he's a 22-month-old toddler at this time. The 11-month-old child also has significant limitations in a large number of areas and will have a long road to overcome many challenges, including some of the same limitations that the parents have, of course, around hearing, for example. So we have children who have special needs. We have parents who also arguably have special needs. So the question is this a situation where I can allow more time for the parents in the hopes that they will be able to take advantage of that? I'm willing to extend that for one more review period before I make a total goal change. As of today, I think recognizing the concerns that we have, that the goal of a dual goal will be set of adoption and reunification. And then it's to signal to the parents that I really need to see dedication to the children's needs and to putting together a household functioning that will support those special needs of your children. So they'll have another 3 months to do that, but also I will signal to the department that there's a recognition that we will be looking at potentially a full goal change at the next review hearing. And if you have that for me to review, if the situation remains the same, I would expect that to move rather quickly after this next review period. In the meantime, the children will remain in their placement that is the safest and least restrictive, considering the circumstances, many of which I've already explored during my analysis of the goal change. There remains a significant risk that these children will not have their medical needs met, will not be able to continue to make progress on their developmental needs, and of course the risk to mental and emotional harm resulting in a change back to the parents wherein those needs would not be met. There's a need to see the parents demonstrate that they're able to avoid having utilities shut off, for example, finding a vehicle, and so many other just basic physical needs of the children would also be at risk. Both parents need to find employment or secure disability. So we'll look for progress in those areas at our next review hearing, which will also be a permanency planning hearing. And we'll conduct that on October 17th at 1:30 p.m. Unless there's any questions, that's all for today. We'll see you in October on the 17th at 1:30 p.m.
Thank you, Judge.